Okay. Thanks. So, is there somebody who wants me to take something, or?
Well, we do have these presents for the city attorney. These are two posters of people with disabilities that have been shot by police. And there's a lot more that the security guards took that are downstairs, and we would like him to have those.
Okay. So the city attorney met with, had previously met with the ACLU.
No, we've asked for a meeting with him, and we have not gotten it.
Did you introduce yourself yet?
Oh, I'm sorry, I'm
I
Matt
was
Dorsy, I'm
waiting
the
for you.
communications director for the city attorney's office. Dennis Ferrer is not in the office right now. I know that there was a letter that we're going to be responding to. I think the city attorney is going to respond next week. I have put the Sheehan brief on the city attorney's website. So if you scroll down to the bottom, there's a blurb that says major cases, and it's the city's brief in the Sheehan case. It walks through all the issues. We think there's some misunderstandings about what the case, that we see this as a fact-specific case. We don't see the court going beyond the narrow part of this case.
Are you an attorney?
No, I'm a press person.
Okay.
But I'm just saying what the people say. That what the lawyers, including lawyers who former Supreme Court clerk, who does not believe that this is going to be a far-reaching undoing of the ADA.
But that's the same court who thinks a corporation is a human being. I mean, we're just really afraid that the court's going to hack away at our rights.
When the city attorney's office says appeals to the Supreme Court to quite possibly, not definitely, but even just possibly create a precedent that would allow the police to shoot my husband without consequences, if it was your spouse, and the ruling might let the police shoot your spouse with impunity, what would you do at the next election?
I think first of all, it's the Americans with Disabilities Act has always allowed for reasonable judgment when there is an emergency situation that endangers life and safety. That has always been the case with this. We believe that on the narrow circumstances of this case, the Ninth Circuit got it wrong. So we're on that narrow piece. But you'll see in the brief that we're saying this is narrow. We're not asking the court to go beyond that. I would invite as many organizations as possible to join us with amicus briefs to say the same thing. There's no reason that the court should go anywhere beyond what we wanted to do, which is to correct the error that the Ninth Circuit made. Remember, this was a case the city prevailed on in the U.S. District Court. So I think we're all in agreement. Like, nobody wants a gutting or
Would you like to take this one,
So
Sawyer?
we're not in agreement, because the Supreme Court doesn't take just any case. It gets thousands of petitions every year. It only chooses those cases in which it wants to make a statement. And we're really concerned about what the statement is going to make. It's not like any other court where the judge actually has to constrain its ruling to the evidence and the briefs that are presented to it. The Supreme Court gets to do what it wants. And the city can take this case to trial. You're absolutely right. The ADA applies, and if there's a danger, a direct threat, there are guidelines for when you use that, and people are not held accountable if there's a direct threat, right? Go to trial with that. If you're confident of that in this case, all we're saying is fine, don't settle it, go to trial, let a jury decide. Don't ask the Supreme Court to be stepping in here. This is not a friend to the ADA.
Yes, your point may be
Excuse me,
valid.
I think everyone should say their name when they speak in their organization. I think that might be helpful.
And be aware too, the City College decision just came out 15 minutes ago. So that's something that we've got to go through. We'll be having a press conference in a couple of hours, but this is the thing we've been on pins and needles about all month. So.
Eduardo Vega, I'm with the Mental Health Association of San Francisco. I think, what we don't want to see is there may be narrow rulings, there may be other ways to proceed in the legal process. But this is essentially holding the ADA hostage in a situation with what might be construed as a narrow sort of ambition or a narrow objective, but which is not going to leave the ADA untouched one way or the other. And the trend in recent years is definitely against people with disabilities. We've seen all sorts of issues with unfair treatment, at least the appearance of injustice with regards to people with disabilities and people of color. Pushing this to the Supreme Court, holding it at the Supreme Court, is putting the ADA at risk.
So we're all, sorry, Jessica Lehman with Senior Disability Action. We're all here today because the city attorney hasn't responded. We all need to talk to him directly. Can you get him on the phone so we can talk to him since we're all here for that?
Yes.
The city attorney is going to be writing a formal response, and I can't do that.
We're all here now.
We're all here.
Thanks so much.
We're all,
I
you know.
Did you see me tomorrow?
Yeah.
My name is Susan Sita. I'm just a member of the community. I'm not with an organization. But I really, what you said about this wanting to deal with this issue just on the facts of this case just makes no sense, because the Supreme Court doesn't deal with factual issues. All they deal with is the law. So they're not going to make a ruling about the facts of this case. So that explanation about why it's being pursued makes no sense whatsoever.
Yeah. This is Tom Hazard.
Appeals are not to resolve factual issues. They're always
Yes,
to
yes.
resolve issues of interpretation of the law.
The issue of what's reasonable is what exists, what's always been in the ADA, is something that they may address. But there's not going to be, as I think I read, an exception.
That's being executive officer. It's executive officer.
Hey, it's Matt. Okay. I'm in front of the group. I have to go. Can you come call back in 5 minutes? Okay. Okay, I'm going to come down. Okay. I really apologize. We are going to have, we have a City College emergency. The court just issued this. It's not our timing.
How does the City College thing precedent over lives?
Education Defense Fund. We would like to set up an appointment now for when he is available.
Okay, let me ask Brittany to come down.
At a definite time, so we can all know exactly when we're meeting with them.
I don't do the scheduling.
I know, yeah.
Let me ask Brittany if she can come down.
Thank you, ma'am.
Great. And anyway, the brief is on the website. It's sfcityattorney.org. And I will put the letter up there when we have it, the formal letter.
The letter from us?